Robbery in General. Article 293. Who are guilty of robbery? Any person who, with intent to gain, shall take any personal property belonging to another, by means of violence against or intimidation of any person, or using force upon anything, shall be guilty of robbery. Robbery is the taking of personal property belonging to another, with intent to gain, by means of violence against or intimidation of any person, or using force upon anything. Classification of robbery. Robbery can be robbery with violence against or intimidation of persons under Article 294, 297, and 298, and robbery by the use of force upon things, Article 299 and 302. Elements of robbery in general. That there be personal property belonging to another. 2. That there is unlawful taking of that property. 3. That the taking must be with intent to gain. And 4. That there is violence against or intimidation of any persons or force upon anything. The property taken must be personal property, for if real property is occupied or real right is usurped by means of violence against or intimidation of persons, the crime is usurpation under Article 312. Prohibitive articles may be the subject matter of robbery. Opium, for instance. The case of U.S. versus Samahim. Facts of the case. While several persons were perfecting the purchase and sale of several tins of opium, certain police officers, conspiring together with some Chinese to obtain possession of said opium, came to the scene and by means of intimidation seized the opium, without causing the prosecution of the offenders, and thereafter said police officers appropriated the opium. Ruling, robbery was committed. Property belonging to another. Thus, one who, by means of violence or intimidation, took his own property from the depositary is not guilty of robbery, since the personal property must belong to another. A co-owner or a partner cannot commit robbery or theft with regard to the co-ownership or partnership property. Article 293 uses the phrase belonging to another, which means that the property taken does not belong to the offender. The person for whom the personal property is taken need not be the owner. Possession of the property is sufficient. In the commission of the crime of robbery, it is not necessary that the person from whom the property is taken by means of threats and violence shall be the owner thereof. It is sufficient if the property is taken from him by means of threats and violence for the purpose of gain on the part of the person appropriating it. The possession of the property is sufficient. Ownership is not necessary. Robbery may be committed from a bailee or a person who himself has stolen it. It has even been held that the taking of clothing from the dead body of a person constitutes robbery as the property of the executor, even if the owner of the property may be guilty of robbery when, for instance, he takes it from the possession of a bailee with the intent to charge the bailee with its values. Question. Does the phrase belonging to another in relation to property taken mean that the naming of the owner is a matter of essential description of the crime? Yes, if the crime charged is robbery with homicide in view of the capital punishment attached to the crime, but when the accused is prosecuted for robbery with intimidation or violence resulting only in physical injuries, or robbery by the use of force upon things, the name of the real owner is not essential so long as the personal property taken does not belong to the accused. In the case of U.S. versus Lahoy, the accused were prosecuted for robbery with multiple homicide, while the information alleged that the property taken belonged to Roman Estreba. The proof showed that the person robbed was Juana Serran. For lack of conformity between the allegation and the proof respecting the ownership of the property, the Supreme Court held that it was impossible to convict the accused of robbery. The accused are each convicted for 4 separate homicides. In the case of People versus Santo Tomas, the Court of Appeals explained the ruling as follows. In the case of U.S. versus Lahoy, relied upon by the defense is predicated upon the facts entirely different from the facts of the instant case. In that case, the allegation of the real offended party in the robbery case was an essential description of the crime, because if robbery was not proved, the complex crime of robbery with homicide, to which the capital punishment is attached, cannot be sustained. The Supreme Court in that case construed the law strictly in favor of the accused because of the seriousness of the crime. In robbery, the personal property of another is taken by the offender against the will of the owner. Robbery can be committed only by taking personal property of another against the latter's will, where the accused received several jewels in trust or for safekeeping from the owner's agent. The said accused cannot be held for robbery because she did not take the jewels. If A delivered a package containing an article to B by mistake, and when A asked for the return thereof, B threatened to kill A, if A would get it back, B is not liable for robbery even if he had intent to gain and employed intimidation because he did not take the property from A. The taking of personal property must be unlawful. Thus, a Secret Service agent who made search for and seizure and seized monies in a dwelling house under lawful orders from his superiors and appropriated a part thereof to his own use before returning over the balance to his superiors is not guilty of robbery. The unlawful taking of personal property is an essential part of the crime of robbery, and where the taking was lawful and the unlawful misappropriation was subsequent to such taking, the crime is estafa or malversation. The case of U.S. versus Atienza. But in the case where 4 Chinese, a municipal treasurer, and a police sergeant, and 2 policemen pretended to purchase opium for certain morals, and then the opium was to be delivered, the municipal officials arrested the carrier of the opium, and they, together with the 4 Chinese, appropriated the opium. It was held that they were guilty of robbery. While the seizure of the opium and the rest of its carrier by the agents of the authorities are lawful, it was not lawful for said agents to seize the opium in order to appropriate it. The fact that agents of the authorities apparently acting in compliance with the law but really with intent to obtain unlawful gain did intimidate, seize a forbidden article constitutes robbery. As long as the authorities or their agents have not legally taken charge of the forbidden article, it continues to be private property, and they have acted not as agents of the authorities in the fulfillment of their duties, but merely as private property parties. Ownership of the forbidden article passes to the government only after legal seizure thereof. Hence, if the agents of the authorities in the beginning lawfully seized the forbidden article and conceived the idea of misappropriating it only after it came into their possession, then the crime would be estafa. Take note, it should be malversation, not estafa. Unlawful taking when complete. So when is unlawful taking complete? There are certain instances. One is as to robbery with violence against or intimidation of persons. 2, as to robbery with force upon things. And that's it. Let's go back. So unlawful taking when complete. As to the first one, as to robbery with violence against or intimidation of persons, it is completed, unlawful taking is completed from the moment the offender gains possession of the thing. Even if the culprit has had no opportunity to dispose of the same, the unlawful taking is complete. The fact that the defendant in his flight threw away the property stolen, or that it fell without his knowledge, does not affect the nature of the crime. Defendant saw his victim put money in his coat pocket. The next day, the defendant held him up and deprived him of the coat, but finding the money was not there, the defendant threw away the coat. Ruling guilty of robbery of the coat, and the offense having been completed when the defendant forcibly deprived his victim thereof. Second instance when unlawful taking is complete is as to robbery with force upon things, where the culprit had already broken the floor of the bodega, had entered it, and had removed 1 sack of sugar from the pile, but was caught in the act of taking out the sack of sugar through the opening of the floor. It was frustrated robbery only. But wala na frustrated robbery karon. It would seem that this kind of robbery, the thing must be taken out of the building to consummate the crime. Taking, as an element of robbery, means depriving the offended party of the ownership of the thing taken with the character of permanency. Example, A was the owner of a gun kept in a drawer which was locked. B, A's son, destroyed the drawer's lock and obtained the gun in order to threaten A with it. In fact, B threatened A with the said gun. Ruling, B had no intention of depriving A of the ownership of the gun with any character of permanency. negativing, therefore, the essential element of taking in the crime of robbery. Take note that the accused in this case was convicted with grave threats under Article 282 for threatening the offended party with the said gun, demanding money, but without attaining its purpose because the offended party reported the matter to the police. Intent to gain. So there must be intent to gain. Intent to gain is presumed from the unlawful taking of personal property. The intent to gain, being an internal act, cannot be established by direct evidence except in case of confession by the accused. It must therefore be deduced from the circumstances surrounding the commission of the offense. As a general rule, however, the unlawful taking of personal property belonging to another involves intent to gain on part of the offender. The taking of personal property belonging to another should not be under claim of ownership. One who takes property openly and avowedly under the claim of title proffered in good faith is not guilty of robbery, even though the claim of ownership is untenable. Absence of intent to gain will make the taking of personal property grave coercion if there is violence used under Article 286. The element of personal property belonging to another and that intent to gain must concur. Number 1. If the accused, with intent to gain, took from another personal property which turned out to be his own property, the property not belonging to another, he cannot be held liable for robbery even if in taking it the accused used violence as against or intimidation of persons or force upon anything. And 2. If he took personal property from another, believing that it was his own property, but in reality it belonged to the offended party, there is no intent to gain. He cannot be held liable for robbery, even if the accused used violence against or intimidation of persons or force upon anything. Violence or intimidation as an element of robbery. The violence must be against the person of the offended party, not upon the thing taken. Theft, not robbery, was committed in case where the accused cut with a bolo the strings tying the opening of a sack containing palay and then took the palay. The reason for this ruling is that Article 293 states that the taking of any personal property belonging to another must, among others, be by means of violence against any person. Case of People versus Villar. Facts of the case: the offended party was headed for Oregon Street, where the accused from behind snatched the bag she was then carrying. The accused ran away after snatching the bag. Ruling: the crime committed is theft. In taking away the bag, the accused did not use violence against or intimidation of any persons. In the U.S. case of U.S. versus Amonte, the case was found to be robbery because after snatching the money from his hand, the offended party was pushed to prevent him from recovering the seized property. In U.S. versus Blanco, besides snatching the pawn ticket from the hand of the offended party, the offender used intimidation on the despoiled party. In People versus Malyari et al., the offenders grabbed the hands of the victim and wrested the wallet from him. The intimidation exists when it causes fear or fright of the victim. Thus, a threat of arrest and prosecution, pointing a gun or a knife to the victim, and the like are forms of intimidation. Intimidation need not be threat of bodily harm. The case of People versus Palabao. Facts of the case: the chief clerk in the office of the municipal treasurer dropped at the sari-sari store for a couple to inspect their petty sales book, which was allegedly defective because the certain sales were not entered. The chief clerk took with him the sales book. The same night, the accused went to the store, bringing with him the sales book, which had been confiscated by the chief clerk. The accused demanded 25 pesos for its return, telling the couple that the municipal treasurer needed amount and threatened the spouses that if they would not give this amount, they would have to pay 60 pesos fine to close the store and to close the store. The accused was able to take from the spouses 5 pesos and only the amount they had and 1 dozen eggs. The ruling: there is sufficient intimidation. The spouses were intimidated to make their choice between two alternatives, which are either to part with their money or close the store and pay a fine of 60 pesos. The accused succeeded in taking the money and eggs through the effect of fear or fright. The violence or intimidation must be present before the taking of personal property is complete. If there is violence or intimidation at any time before asportation is complete, the taking of personal property is qualified to robbery. It is not necessary that the violence or intimidation should be present from the very beginning. If defendants entered a house by cutting the rope that tied the door, opened the trunk, and were able to take the money in the amount of 36 pesos from the trunk. When discovered, one of them struck the owner in the mouth. Ruling, robbery with violence was committed. But if A picked the pocket of B and ran away with the latter's wallet containing money bills, and when B chased and overtook him, A turned around and boxed the face of B, inflicting slight physical injuries, or intimidated B with a knife, the crime committed is not robbery with violence against intimidation or persons. A committed two crimes instead. One is theft under Article 308 and slight physical injuries under Article 266 or grave threats, Article 282, Paragraph 2 for intimidating B with a knife. Exception. But when violence results in homicide, rape, intentional mutilation, or any of the serious physical injuries penalized in paragraphs 1 and 2 of Article 263, the taking of personal property is robbery complexed with any of the crimes under 294, even if the taking was already complete when violence was used by the offender. In defining the special complex crimes penalized in paragraphs 1, 2, and 3 of Article 294, the phrase by reason or accompanied by is used, which indicates that if the violence resulted in homicide, rape, intentional mutilation, or serious physical injuries is used by the offender after the taking of personal property belonging to another, the crime is still robbery complex with any of those crimes. Although the killing of Evaristo Tovera by the robbers was perpetrated after the consummation of the robbery and after the robbers had left the victim's house, the homicide is still integrated with the robbery or is regarded as having been committed by reason or on occasion thereof. The case of People versus Barot. Take note that Evaristo Tovera was one of those who constituted themselves as rescue party and repaired to the vicinity of the house of Francisco Lazaro, the victim of the robbery. But the taking of personal property need not be immediately after the intimidation. The complainant was told by the accused, who called himself one of the Secret Service divisions of the Philippine Constabulary, that he was apprehended because he was sending a letter outside the Philippines, an act which was against the law, and that he would be taken to the camp. He asked from him 5,000 pesos, otherwise he would be deported. Being ignorant of the law, he thought, as he was made to believe, that he did something wrong. He haggled with them until the amount demanded was reduced to 2,000 pesos. He promised them that should I finally give the amount, then the alleged case against me would be dropped. Securing the money from someone, he gave it to the accused, in turn gave the letter to him. Ruling, the accused is guilty of robbery by means of intimidation. In the case of People versus Xiong. Using force upon anything. Robbery is also committed by using force upon anything in taking personal property belonging to another with the intent to gain. But the use of force upon things which shall not make the taking of personal property robbery if the culprit never entered the house or building. Thus, removing by force the tires of an automobile while parked on the street and taking them away is not robbery because the culprit did not use force to enter a house or building. Breaking the glass of the show window of a bazaar and thereafter taking 40 watches of various makes valued at 627 pesos and 50 cents is not robbery, it appearing that the accused did not enter the building but merely introduced his hand through the broken glass in order to remove the watches from the shop window. Entrance into the building must be effected by any of the means described in Articles 299 and 302. But such entrance into the building is not necessary when the robbery is committed by breaking wardrobes, chests, or any other kind of locked or sealed furniture or receptacle inside an inhabited house, a public building, or an edifice devoted to religious worship, or by taking such furniture or object away to be broken or forced upon outside. Subdivision B of Article 299, or when the robbery in an uninhabited building other than a public building or edifice devoted to religious worship is committed by breaking any wardrobe, chest, or any sealed or closed furniture or receptacle, or by removing a closed or sealed receptacle, even if the same be broken open elsewhere. paragraphs 4 and 5 of Article 302. Distinctions between effects of employment of violence against or intimidation of persons and those of the use of force upon things. So, unsay kalainan nila? There are still things that qualifies robbery, but how are they different? Again, employment of force against or intimidation of persons and those of use of force upon things. Number 1. Whenever violence against or intimidation of any person is used, the taking of personal property belonging to another is always robbery. If there is no violence or intimidation, but only force upon things, the taking is a robbery only if there is force used either to enter the building or to break doors, wardrobes, chests, or any kind of locked or sealed furniture or receptacle inside the building, or to force them open outside after taking the same from the building. 2. The robbery with violence against or intimidation of any person. The value of the personal property taken is immaterial. The penalty depends on 1. A result of the violence used, as when homicide, rape, intentional mutilation, or any other serious physical injuries resulted, or when serious or slight physical injuries were inflicted, which are only evidence of simple violence, and 2. On the existence of intimidation only. But in robbery with force upon things, committed in an inhabited house, public building, or edifice devoted to religious worship, the penalty is based on 1. The value of the property taken, and on whether or not the offenders carry arms. And in robbery with force upon things committed in an uninhabited building, the penalty is based only on the value of the property taken. Classification of robbery: when both violence or intimidation and force upon things are present. So what if both qualifications are present in one instance of robbery? When the offender, in taking personal property belonging to another with intent to gain, employs violence against or intimidation of any person, the crime is robbery with violence against or intimidation of persons. Even if the robbery was committed in a dwelling house, after the offender had entered the same through a window or breaking its doors or walls, the offender cannot be held liable for robbery with force upon things under Article 299. The lower court erred in convicting the appellant under 299 of the revised penal code as amended and in applying to him the penalty there provided. Aside from the fact that the information to which the appellant pleaded guilty did not allege that the robbery was committed under any of the circumstances enumerated in said article, such as entering the house through an opening with not intended for entrance or egress, the breaking of doors, etc., it's now settled that where robbery, though committed in an inhabited house, is characterized by intimidation, these factors applies the controlling qualification so that the law to apply is Article 294 and not Article 299 of the revised penal code. This is on the theory that robbery which is characterized by violence or intimidation as against a person is evidently graver than ordinary robbery committed by force upon things, because where violence or intimidation against person is present, there is greater disturbance to order or society and the security of the individuals. And this view is followed even where, as in the present case, the penalty to be applied under Article 294 is lighter than that which would result from the application of 299. In accordance with this view, the appellant should have been declared guilty of robbery under Paragraph 5 of Article 294 of the revised penal code as amended by Republic Act No. 18, since the charge to which he pleaded guilty alleges robbery through intimidation of persons, from the case of People versus Sebastian and Pangilinan. Republic Act Number 6539, approved August 26, 1972, is the law applicable when the property taken in robbery is a motor vehicle. Republic Act Number 6539 defines carnapping and provides penalty therefore. Carnapping is the taking, with intent to gain, of motor vehicle belonging to another without the latter's consent, or by means of violence against or intimidation of persons, or by using force upon things. Section 14, penalty for carnapping. Any person who is found guilty of carnapping, and this term is defined in Section 2 of this Act, shall be irrespective of the value of the motor vehicle taken, to be punished by imprisonment for not less than 14 years and 8 months, and not more than 17 years and 4 months, When carnapping is committed without violence or intimidation of persons or force upon things, and by imprisonment for not less than 17 years and 4 months, and not more than 30 years, when the carnapping is committed by means of violence against or intimidation of any persons or force upon things, the penalty of reclusion perpetua to death shall be imposed when the owner, the driver, or the occupant of the carnapped vehicle is killed or raped in the course of the commission of the carnapping or on the occasion thereof.